Hello, we're here tonight to talk about Chapter 19, but before I start, I have a contractual obligation with my tech support, who at all times stays 6 feet away from me. So this person that you are looking at right now is Grant, and he is my own personal tech support. Grant, want to say hi?
Yeah, hellos. I am weird, by the way. Have fun listening to my grandma.
Okay, hi. The purpose of these lectures and why I decided to put them on YouTube so that you could look at them anytime that you were able to, not necessarily at the class times that we have, is kind of to give maybe a more practical spin on some of the things that are in the chapter. You can still go ahead and look at the PowerPoints that are produced by the publisher, and then I will be doing these lectures. You should by now have gotten from Canvas a syllabus that outlines everything that we're going to be doing from now till the end of the semester, and it talks about when every item will be due. Due tonight, the same night that I will be putting this video online, is the review number 2. That will be due today. How you get that to me is up to you. I would suggest that you send it to me as an attachment with an email. It's easier for me to get that way and then to grade it. You should also have gotten the small claims assignment. I did have to change this assignment. We can't do it as a group face-to-face in class. But what I will be doing are the same questions that I would be giving the groups to do, and then you can turn them back into me. At the very end, I'm going to take a week and I'm going to contact each one of you. Not for a long time, probably just for a few minutes. That's why I have to have a way to talk to you on the telephone. If I don't have a number, please get one to me. And that, discussion will last maybe 10 minutes, and then that's going to be worth the final 10 points for this. So that means the small claims project is still going to be 40 points, just like it was originally. The tests are all going to be worth 100 points, just like originally. And the reviews are going to be worth 20 points each, just like originally, so that we can stay as close to what original plan for the class was. I have gotten some questions from people, and the questions don't really have anything to do with business law. They have more to do with how to figure out their grades and how to get things off Canvas and what they should have. Let me tell you just a little bit about the grades. Don't look at percentages. I switched it all to points. It should be showing up as points, but don't look at percentages. Right now, the only thing you have is a test worth 100 points and a review worth 20 points. Everything else is extra credit. So right now, we have 120 points. If you've done all the extra credit, you might have 130 points. And that's what you need to look at, are the points. It's really way too early in the semester to try to figure out your grade, because we still have 2 more tests, 2 more reviews, and the small claims project. But looking at it, most of you are doing quite well. Also online tonight, if you look at Canvas, you'll find the normal outline, breaches and remedies, and you will also find 2 documents. One I realized did not scan very well, but 2 things that I'll be talking about tonight. You can look at those, and they're all on Canvas. If for some reason you can't get any of these things, be sure to let me know. All right, so let's start talking about Chapter 19 and what this is about today. We've come to the point now where we have all of the elements of an enforceable contract. If you remember, it's the agreement between competent parties with genuineness of assent. There has to be consideration. It has to be for a legal purpose. And it has to be in the proper form, whatever that form might be. We've talked about what happens if a third party gets involved somehow with an incidental beneficiary or someone, that we don't care about. And then we have gotten to the point where the contract ends. That was last time, a discharge of contracts. How do we end a contract? Frequently, without being mad at each other, every contract sooner or later has to come to an end. But tonight, we are talking more about, okay, what happens when things don't work out so well? with your contract, and the parties are not happy with each other, and they feel that something has gone wrong, and they want a remedy. And that's what we're talking about tonight. I will also mention that I thought the last video was kind of long. I know it was like 45 minutes, kind of long. So I'm going to be doing them in shorter segments. This is a much shorter chapter, so it probably won't be as long. There are a couple of other chapters that are kind of long chapters, so I'm going to be doing the videos in 2 different parts, so that when you sit down to watch them, you can get up and move around if you have to. All right, so breaches and remedies. Let's talk about what is a breach, first of all, in a contract. A breach of a contract is a failure to act or to perform in the manner that's called for in the contract. A breach in many contracts, and remember after class I want you to start reading every contract that you enter into or sign, there is almost always a paragraph in there somewhere that defines what a breach might be. For example, if you leased a car, there might be something in your lease agreement that says that you're going to keep insurance on this car. If you don't, it's a breach. That you are going to make payments monthly on this car. If you don't, it's a breach. That you are going to keep the car in state unless you notify the company or you're just going on vacation. That the car is going to stay here. This is the state that it's going to be in. And if you don't do that, it's a breach. It pretty much tells you, do this or there's a problem. You have breached this contract. So remember, a breach is when it was a failure to do what you've promised to do in the contract. All right, now, there is this thing called anticipatory breach, something that you probably hope will never happen to you in a contract, because there really aren't remedies that are going to be all that good for you. You're going to get to the end of this and go, oh no, what happened? An anticipatory breach is when a party, one of the parties to the contract, either by their words or by their conduct, doesn't have to be language, they don't have to call you up on the phone and say, I'm not going to do this. It could be the conduct, it could be what they do. They make it absolutely clear, no weasel words, it's unequivocal before the time for performance in the contract that they're not going to do it. Now, this could be something like it's the day before they're supposed to deliver all their widgets to you, and you know they only have one factory, and that one factory has just burned to the ground and everything inside it was destroyed. Well, performance isn't due until tomorrow, but it's a pretty good chance it's not going to happen. Or the other party to the contract could call you up and say, look, we ran out of money, we can't get a source to supply, whatever. We aren't going to be able to perform that contract. So the anticipatory breach is when either words or conduct makes it clear, absolute, and unequivocal before the time for performance, they're not going to do what they promised to do. Okay? All right. We'll come back to anticipatory breach. It comes up quite a bit in the chapter when we get to the Uniform Commercial Code. We talk about the law of sales. We'll be talking again a little bit more extensively about anticipatory breach. And we'll be talking about, just in a few minutes, about what it is possible for you to do if there's going to be an anticipatory breach. Okay, now, there may be a breach of contract, and the other side decides to waive the breach. You did something that you shouldn't have done, or you didn't do something that you should have done, and the other side says, look, I know you messed up here. I know you didn't do exactly what you're going to do, but I'm going to say it's okay. All right, for example, you're supposed to pay your rent by the 1st of the month. You don't pay your rent till the 5th of the month, and the landlord doesn't do anything about it. The landlord takes your rent and said, I know you're late. I'm going to ignore it this time. That's a waiver of the breach. And what it does is it really says the breach didn't happen. I'm going to pretend like it never happened. Now, most contracts, again, you're going to start reading those contracts. Most contracts that you sign now have a clause in them that says, of course not in these words, but this is what it's saying, if we were nice to you this time, and we decided we were going to let you get by, but we're not doing it again. This is a one-time only deal. And just because your rent came in on the 5th this month and we took it and we said it was okay, doesn't mean that we've changed and now your rent is due every month on the 5th. So you are waiving the breach only for what happened, only for that one item, not for the whole contract. You're not rewriting the contract. It's only the matter that was waived, only that applies. Okay? And in order really to waive the breach, the other side has to know you've breached it. All right? Then another way you can approach a breach is what's called a reservation of rights. A reservation of rights means that you accept a defective performance, but you keep the right to sue them if you've lost any money. For example, and most of these lectures I'm going to try to use the examples that there are in the book instead of coming up with a lot of different ones, partially because that way if you're following in the book you know what I'm talking about, and also partially because it's hard when I don't see you and I don't get any feedback from you to know exactly which examples are working and which ones are not. So I'm going to kind of stick to the ones here. But I think they talk about in the book where a company is desperate to get coal. They have to have coal. And they get a delivery of coal, but it's defective. It doesn't exactly say why, whether it's not enough or whether it's an inferior product, whichever. It's not the performance that was expected, but they have to have the coal. So they take the coal and they say, okay, we all know this is not the coal we ordered. This is not what we wanted. This is not what you were supposed to deliver. But we're going to take it, and then we're going to sue you for any damages that we have. If we lose money somehow, if we have to go buy it somewhere else on the market, and it costs us more, or whatever it is that they suffer as a damage, we're going to take what you've got and we're going to sue you. We reserve our right to sue you. I mean, they're not saying, yeah, absolutely, we're going to sue you. You can work it out, whatever you want to, but we keep our right. That's what reservation of rights means, is that we're keeping our right to sue you if we want to. Okay, so let's get into what our remedies are here for these different types of breach that we have. And let me tell you, these are the main remedies. And people get confused a lot when we start talking about which ones are the remedies and then which ones are an explanation of the remedies. Okay, these are the remedies that are outlined in the book. These are the most common remedies that you would have for a breach of contract. Okay, and they are damages, rescission, specific performance, injunctions, and reformation of the contract. So when we're talking about breach of contract, those are the most common remedies. Let me just do that one more time. It's damages, rescission, specific performance, injunction, and reformation of the contract. Those are the remedies. Okay, so, but before we get into those remedies, let's back up again and talk a little bit about that anticipatory repudiation. And if you remember, the anticipatory repudiation is when the other side, by clear, absolute, and unequivocal words or behavior, before the time for performance, says we're not going to perform. Okay, what can you do? And let me tell you, and then you'll see why this is a tough position to be in. And remember, we're talking lots about businesses. This is a tough position for a business to be in. First thing they can do is do nothing and just assume that when performance was supposed to be done, it was going to be done. The problem, of course, with that is what happens if the time comes and performance isn't there? Then you have a lawsuit for damages. The second thing you could do was to, if you're sure that the other side is not going to perform, that you regard the contract as already broken and you bring a lawsuit. The problem is, you bring this lawsuit, and what if the court says there was no clear, absolute, and unequivocal word or conduct that made it look like this contract wasn't going to be done? I think they were going to do the contract. And they find against you. Then you're the one that's going to wind up paying damages to the other side. Because the court found you weren't right when you said that they were going to repudiate their contract. The third remedy then is to regard the repudiation as an offer to cancel the contract. And I suppose if any remedy is any good, that's probably the one. But you say to the other side, look, you can't do it. We both know you can't do it. Let's just cancel the contract. And at least that releases you to go out and enter into another contract with somebody else. And if you've canceled the contract, then you're good. You're not going to have obligations to each other. Okay? All right. But again, being in a position where the other side is going to breach the contract, and you know that before time for performance, is not a good place to be in. All right? And then also, we have talked before about what happens when, for some reason or other, you don't have an enforceable contract. You thought you had consideration and you didn't have it. You thought you had an offer and acceptance and you didn't really have it. What happens when you don't have an enforceable contract? You can seek, and we've talked about this several times before, you can seek quasi-contract relief. Okay? Quasi-contract relief is equitable. You're going into the court and asking them to do what's fair and what's right. You don't have a contract. That's the first thing. Before you ask for quasi-contract relief, you got to have no enforceable contract. So that happens, and then you ask the court to give you damages and the measure of damages, because when we talk about going in and asking for damages, which is money, there's always a standard. And in this case, the measure, that's what it's called, the measure of damages is the reasonable value of services rendered. It's not what the contract says, because we don't have a contract. It's the reasonable value of services rendered. And if you were actually in court in a lawsuit, you would have to have somebody come in and testify for you as to what the reasonable value of services rendered was. Okay? All right. So let's assume, however, that we do have an enforceable contract. We have an enforceable contract. Unfortunately, it did not get performed. And we have a breach. And if you remember, a breach is a failure to act or perform in whatever way it called for in the contract. Something went wrong. Okay. There are different kinds of damages. There are compensatory, nominal, and punitive. Let me just tell you here, this is where people start getting really confused. The remedies are damages, rescission, specific performance, injunction, reformation of the contract. When we talk about damages, there are different types of damages: compensatory, nominal, and punitive. Okay, so try to keep those clear in your mind. Okay, when we're talking about damages, and frankly for a breach of contract, this is usually what we're talking about. And you do have to remember that when we're talking about a breach of contract, we're talking about what's going to make you whole, what's going to make you right. But we really don't care about your pain and suffering when we're talking about breach of contract. We could be talking about businesses, we could be talking about people in businesses, and we know you feel bad, and we know that you're really, really upset about what has happened, but that's not going to come when you're suing someone or you're in an action for a breach of contract. Those are for the negligence actions that we talked about before. Those are for those other things that we talked about. You can, if you feel bad, you can find a cause of action in one of those areas. But if your cause of action is in your breach of contract, you're not going to get damages for your suffering and pain. Okay? All right. The most common type of damages that you might get would be compensatory. And compensatory breaks down into two parts: direct and consequential. All these things break down into groups. Look at the outline that I gave you and be sure that you're clear on what groups we're talking about. Right now, we are under remedies, we are under the remedy of damages, and we're talking about the types. So compensatory damages are direct, and direct includes incidental and consequential. So compensatory damages, excuse me, tech support, are we still good? Okay, when we talk about compensatory, and we're talking about direct, and we're talking about consequential. Direct damages are the ones that flow naturally from the breach of contract. So, if I want to buy an iPad from you, and I'm going to pay you $150 for your used iPad, and you don't give me the iPad, and I give you the $150, you owe me $150 back. That's our direct damages. That would happen every time I entered into a contract with you to give me an iPad for $150 and you didn't do it. Then the $150 is going to be the damages all the time. That's what's going to happen every case. You buy a bottle of pop from one of the machines. You put in the money. What is it, $1.50 now? You put in $1.50. You don't get your pop. Your direct damages are $1.50. Now, it may be horrible to you. You may have desperately needed the caffeine to get through class that night. You may have had to have that thing and you just didn't get it. We really don't care. Your direct damages are the $1.50 that you put into the machine and didn't get your pop. Okay? All right, now, we also have, and let me give you just a little bit with the example that's in the chapter, where he goes in and he buys a truck and tells them that he has to have this truck. He has to have it by a certain date because he's got to get into the fields to harvest his crop before the first frost. And he tells the salesperson this, and everything is fine, and it seems like everybody agrees you're going to get your truck in time to get there, okay? Well, he doesn't get the truck. He has to go get another truck. He has to pay more money for that other truck. So his direct damages are going to be the extra money that he has to pay to get that other truck. Because he has to get a truck. He has to have that, and he's told them why. Now there might be some incidental damages. These might be extra expenditures that he has to make in order to mitigate his damages, and or to fix the breach, and we'll get to that in just a minute. Okay? So there, depending on what's going on, there might be, maybe not in the situation with buying the truck, but there you might have to, if you had items that you had sold, and you have to store them for a few more days, you might have storage costs, or you might have insurance costs that you have to pay, or you might have to advertise them again and pay for advertisement so that you get another buyer to buy your product. So it's direct. But directs are ones that flow naturally from that breach of the contract. Consequential damages are ones that don't happen every time that contract gets breached. They must be reasonably foreseeable. So in the one where he was buying the truck, he told them he had to have the truck in order to harvest his crops before the first frost. They promised him his truck. It didn't come in. He wasn't able to get another truck in time to get a lot of the crop harvested before that first frost. And he lost the money for all of that. not everybody whose truck was delivered late is not going to be able to harvest their crops. That's not going to happen every time there's a late delivery of a truck. In this particular case, it did happen, and it was reasonably foreseeable according to the courts because he told them that's why he had to have the truck by that date, and they acknowledged that he had to have the truck by that date, and they promised him the truck by that date. So this was like a little bit different, not the ordinary damages that you might get, but it was reasonably foreseeable. And in Michigan especially, those two words get used a lot in lawsuits, and they get used a lot by the court. Okay, let's talk about another kind of damages, and that's nominal damages. Nominal damages are where they say, yeah, there was a breach of contract, and yeah, the other side is wrong, but you really weren't harmed all that much. And so we're going to give you a little bit. Nominal is not a whole lot. Okay? There's also this thing called punitive damages. Punitive damages are not something that are easily obtained in Michigan. We don't seem to like punitive damages much. But punitive damages are ones that many states give purely as punishment. They don't really have anything to do with what happened in the contract, except that they don't like the behavior of the party that breached. It wasn't just they couldn't perform, just an ordinary kind of business thing. It was like they really don't like what the other side did. And they're going to make sure they never do it again. So they tack on a huge amount of damages that has nothing to do with the actual losses. A lot of times, punitive damages are the ones that they talk about in the newspapers, they talk about in the news feeds. It sounds, horrendous. There's these multi-million dollars that they've awarded in punitive damages. A lot of times when that gets to the appeals court, because the other side frequently will appeal that, it gets to the appeals court and they're greatly reduced. Or the parties will get together and they'll agree, I'll give you money now if you'll agree to take less than the court ordered. And the punitive damages get reduced a lot, but that part doesn't get into the news very often. Okay, but not very often given in Michigan, sometimes called exemplary damages, but those are the three kinds of damages, okay? Compensatory, nominal, punitive. Compensatory are direct damages that flow naturally in any given type of breach. This is what's going to happen. And they include incidentals. And consequential damages that happen this particular breach, but wouldn't happen every time this breach occurred. But the other side has got to be able to have reasonably foreseen that this might happen. Okay, so what happens if the other side does mess up your contract? They're the ones that breach, not you. You're the innocent party here. You still have to mitigate your damages. Mitigate your damages means you can't just sit back and say, that's it. They've breached. I'll just wait till my lawsuit comes through and they hand me the check. You can't do that. You have to take steps to try to keep your damages as low as possible. So that guy who was buying the truck to harvest his crops, when the truck didn't come in, he had an obligation to go out and try and find another one, which he did. It just was late and he had to pay more money for it. But he had to go out and try to keep his damages down as low as he could. This has been known to happen in labor disputes. When somebody gets fired and feels that they should not get fired for whatever reason, that they were terminated, that's either statutorily incorrect or they're contractually incorrect, or for some reason they shouldn't have been fired. And so they may go to arbitration or they may file a lawsuit. And in the meantime, and this is one case that I actually know very well, the person was fired. She claimed it was incorrectly. In the meantime, while she's appealing this through a contract and then was planning on going to court. She got another job, and it turned out that she made a whole lot more money at the other job than the one that she got fired from. No damages. They had to drop the lawsuit. There's no damages. Now that doesn't always happen when you try to mitigate, but you've got to make an attempt to keep your damages down. You can't just sit back and hope, okay? You just have to do that. All right, so what are some of the other remedies? Well, one is rescission. Rescission is a remedy it's not real practical. Rescission says that you will put everything back the way it was. It's an equitable remedy, and there has been a material breach. Can't just be a little nothing thing. It was a really bad breach of the contract, and the party wants out, but the contract's already been done. So now what you're trying to do is put everything back the way it was. And I mean, as a practical matter, that's a difficult remedy to do. The court and everything else may say, we agree with you, there was a material breach of this contract and everything should go back the way it was. That's the purpose of rescission, is to put your injured party in the same position they were in before the contract was made. Sometimes it's just difficult to do that. Let's say that the contract you want to rescind is one where you bought a house and it was supposed to be, the basement didn't flood. And everything indicated the basement didn't flood. And then you find out the basement floods all the time. You went out of this contract. Well, unfortunately, the seller probably took your money and spent it. They either bought a new house or they bought something else. They're gone with that money. So it's like, okay, how do you get it back? So that would be what rescission would be. Rescission would say you can give the seller back their house and the seller will give you back their money. If that's possible, great. It's just not always possible that rescission will work. Okay, another remedy is specific performance. Specific performance is the remedy that everybody wants and almost nobody can get. Specific performance says that you're going to make the other side do what they promised to do. That's what everybody wants when there's a breach of contract. You always want the court to tell the person, no, you can't breach this contract. You promised to deliver 100 widgets, you deliver 100 widgets. That doesn't happen. Specific performance only happens when it's real property. And we haven't done that chapter yet. That's the next chapter we're going to do when we're going to talk about exactly the definitions of real property and personal property. But this applies to real property, houses, buildings, easements, rights in the lands of another, those kinds of things, real property. And unique personal property. Unique means one of a kind. By the way, you can't have something that's very unique. It's either unique or it's not. Unique means one of a kind. If that's the situation that you're in, then you can ask the court to get specific performance, to make the other side do what they promised they would do. It does not apply to personal services contracts. Now, sometimes it's not specific performance you're getting when you get your job back. Specific performance means that I could make you do something, and we don't do that in personal services contracts. It's real property or unique personal property. Usually when we're talking about unique personal property, we're talking about an antique. If someone had agreed to sell you an antique, and then they change their mind, and they won't go through with it, and they won't sell it to you, that might be a situation where you could go into the court and say, make them sell me that antique. You can't get it anywhere else. And the court, in that case, may award specific performance. Okay, the last two, we've talked about injunctions before. The last two remedies, we've talked about injunctions before. Again, it's an equitable remedy, so specific performance. Injunction is an equitable remedy. It's always in the negative. You don't positively make somebody do them. If it's an injunction, you're telling them to stop doing something. And we've talked a lot about injunctions before, so I'm not going to spend a lot of time on that. And then we can have reformation of a contract. Courts don't like to reform contracts. That's not their job. They didn't negotiate the contract. They don't, unless it's an absolute clear error or maybe somebody putting some information in there that was clearly a mistake on their part, they're not going to do that. But reformation of a contract would be when the court came in and rewrote the contract. Doesn't very often happen. Okay, so in your contract yourself, you can put some things in that would help to protect you. You just have to be knowledgeable about what you're doing. Okay, first of all, let's talk then about liquidated damages. Liquidated damages are damages where when you enter into the contract, and generally speaking, when you enter into a contract, you're still talking to each other, you're still pleased with each other, nothing's gone wrong. You say, yes, if this contract is breached, there will be damages. But we don't exactly know how much. So what we're going to do is we're going to make an educated guess right now as to what it might be. And we're going to say in our contract that if you breach the contract in this way, this is how much you will pay. And we agree on this when we're entering into the contract. For example, let's say that we're building a Burger King. And we have a contract that says the Burger King is going to be ready by November 1st because we want to start selling things, selling burgers and whatever, for people who are going to be doing their holiday shopping. And we put in there, because we've done lots of market studies before we build this Burger King, that we don't know exactly, if you're late, we don't know exactly how many burgers we would sell between the time that you should have built the place and the time you actually finished the place. We don't know exactly, but we have a pretty good guess based on our market studies. So we're going to say, and this is in no way reality, I'm just picking these figures. We're going to say for every day that you're late, you owe us $1,000. The builder goes, okay, that's fair, I agree. That's your liquidated damages clause. Now, as long as it doesn't look like it's a penalty, the courts will enforce them. For example, technically, your late fee in a lease is a liquidated damages clause. If you don't pay your rent on the first when it's due, they'll send you a notice. And they don't have an exact idea of how much it really costs them, but they estimate that in order to send you notices, we have a clerical staff that we have to have prepare it, we have to have somebody send it out to you, and so we're going to say this is the amount that it's going to cost us to collect your rent if you're late. Well, if it is, and again, I'm just pulling these amounts out, if it is $45, okay. If it was $1,000 for being one day late with your rent, probably not okay. That's probably a penalty. And we don't enforce liquidated damages clauses that are penalties. Now, a lot of contracts now have found that putting these liquidated damages clauses where you've got amounts to pay if you don't perform on time, that it works much better when they started saying, we're going to give you a bonus if you finish early. They've done this on a lot of road construction projects now. Instead of saying we're going to, you're going to have to pay $10,000 a day if you're late, we start saying, oh, well, we'll give you $5,000 for every day you're early. Sometimes those work better. Okay, attorney's fees in the United States, the general rule is everybody pays their own attorney's fees. You can change that by contract. You can change that by statute. But it has to be it either has to be in the statute or in your contract that you have set up about attorney's fees. The general rule is everybody pays their own. All right, and the last thing I want to talk about are limitation of liability clauses. And these are the two examples that I placed on Canvas for you. One is much clearer than the other. So I want to look at the one that's not real clear. It's from a publishing company. And what I wanted to direct your attention to in that, in about the middle, it says, and just look at this when you're reading it, the publisher's maximum liability to the customer cannot exceed the price of the advertisement. This was taken from a contract that people were buying advertising. And they're saying, you know, if we make a mistake putting in your advertising, we spell your name wrong, we put a wrong address in, whatever it is, you read the rest of it, it doesn't matter what it is. Our liability is limited to what you paid for the advertisement. We are not going to pay for anything else. And it says in that same thing, in no instance will the publisher be liable for lost profits or any other consequential damages, including exemplary, incidental, indirect, or punitive damages. These are the kinds of clauses that you find in contracts. The other one, again, is for some online banking, and it's the same thing. It's where you have a limitation of liability clause. And I just want to read this to you because it's real brief, but it says, while we strive to deliver a valuable and error-free service whenever possible, your use of online banking is at your own risk. The bank is not liable for any direct, incidental, consequential, indirect, punitive, or other damages of any kind arising out of your use or access to online banking, your inability to use it, and you agree you are solely liable for any viruses, worms, Trojan horses, or other similar harmful components that may enter your computer or your computer system or equipment by downloading information from our online banking site. This is a limitation of liability clause. That's what they're talking about in the book. In some cases, there are FTC regulations, if you remember that's the Federal Trade Commission, to protect consumers. They don't let them go quite as far as some of these provisions might like to, but otherwise, read contracts that you enter into because you might find these limitation of liability clauses. Chances are good, if you are a small business or a consumer entering into one of these, that it's not going to be really to your benefit. You are agreeing to assume a lot of risk. Okay? And the last is releases. And again, we've talked about releases before. You can agree that before performance, before being allowed to do something, you're going to release them from liability. For example, we talked about that. If you're going to be walking in the Thanksgiving Day parade, you or your parents, if you're under 18, have to sign a document that pretty much releases them from liability for all things. And we talked about that when we're talking about the torts chapter. Just remember that a release of liability does not apply if there is gross negligence. And gross negligence is way more than accidental. We talked about that before. All right. If you have any questions about what is in this chapter, email them to me. This chapter I'm putting online, if you're reading it, you'll know, on the 25th of March. Also, I'm putting the test online on the 25th of March. When you go to read the test, there will be the test and there will be an answer sheet. The only thing I want you to return to me is the answer sheet. I don't want the questions back. It's going to be, tricky for me. I have to figure out how to correct 30 pages or 30 students' tests coming back this way. It might take me just a little bit longer than normally does to correct these. But it would be easier for me if I don't have to look at the questions, if all I have to look at is your answers. So answer them on the answer sheet, print it out and type it in there, handwriting it in there. That doesn't matter to me. I know that a lot of you weren't planning on taking an online course of any kind. The test will be on there. You can do it any time between the 25th of March and the 30th of March when it's due. Now you have to get these into me on time because I have to have time to correct these. So it'll be on there for like 4 or 5 days. That gives you a week. Use resources available to you to answer the questions. If you have any questions about the test, ask me before you take the test. Okay? All right. Thank you for listening.